watching WeAllBe News Radio, News Free Dixie for the 21st century. I'm Thaddeus Matthews.
It's so true, Judge. I want to talk about this because I know you brought this up. I was out of town, but I just want to get your thoughts about this situation. I'm gonna share the screen. This Latoshia Daniels. She was accused of killing her lover, who was a Memphis pastor, a prominent Memphis pastor. I'm gonna read a little short synopsis, and I'm gonna get your take on it, Judge. It says Latoshia Daniels has been found guilty of shooting a Memphis pastor and his wife at their Collierville home back in 2019. A Shelby County jury returned a verdict Friday. This came out November 7, 2025. Finding her guilty of second-degree murder and reckless endangerment. Daniels was originally indicted on charges of first-degree murder, criminal attempted first-degree murder, and employing a firearm during a felony, the third and final count for which the jury found her not guilty. Interesting. It's been 6 years since she pulled the trigger. Daniels, now 46, spent 4 years in jail leading up to the trial. With Friday's guilty verdict, she's looking at a lot more time behind bars. When Daniels took the stand, according to her attorney, she shared details about her relationship with Pastor Broads Perry, claiming he was manipulative and controlling. Okay.
My reaction to that whole thing, you have to understand, the first criminal case I tried as a defense lawyer was in 1975. That's 50 years ago.
Mm-hmm.
I have had several thousand trials as a defense lawyer, prosecutor, and even more as a criminal court judge, elected to 2 terms, 8 years each, in one of the busiest criminal jurisdictions in the United States. At the time, it was the 5th busiest. And quite frankly, I have never seen such an incompetent prosecution in the entirety of that half century. That was pathetic. I listened to this self-serving testimony by the defense lawyer. Did you not, in fact, find that, well, she didn't even do it that way. You were going home and you were going to find out what was going to go on, and that was aggravating you because that was wrong the way he put you in that kind of position, wasn't it? Hey, where's the objection? This went on for 2 some hours. I listened to it. It was televised live. Not one objection from the prosecution. And then when the prosecution had the opportunity to tear her a new one on cross-examination, I don't think they stayed up 5 minutes and they didn't even ask anything. It was absolutely pathetically investigated, pathetically prepared, and pathetically tried. The judge in question, I don't know who that woman was. I'd never encountered her before. I was astonished that she let that go on in a courtroom. I'm saying, where is she going to say, will counsel approach and then ultimately take the jury out? We have some things to discuss. Excuse me, but what is all of this leading question here? Are we supposed to swear in the defense lawyer as a witness? Et cetera, et cetera. And then when they get out and say, ladies and gentlemen, the court has an instruction, statements, remarks, and arguments of counsel are not evidence, and you are not to consider them as having any weight at all when it comes to evidence. They are only designed to assist you in understanding the law and its application to the evidence. But what the lawyers say is not evidence. I mean, I never have seen such an embarrassing incompetence in the prosecution. It was like they were trying to give it away. And considering their sentencing guidelines, and this woman is a first offender, she may almost be in a time served situation.
Yeah, they're going to sentence her on December 17th, so she's facing at least 13 years in prison, from my understanding. Yeah,
and then when you get that, that's parole and all this other stuff. See, here's the other thing. They let her get away with reading to the jury approximately a 5-page suicide letter, which is absolutely astonishing. It's something that I was shocked the prosecution did not argue, showed transferred intent, and also premeditation. In other words, she laid out in that suicide letter what her defense was going to be if she didn't kill herself. And then there is no greater demonstration of intent to commit a crime, to be premeditated about it, to contemplate it, to engage in wickedness where it wasn't spur of the moment when you write out a suicide letter or note. So there's this thing called transferred intent, and I didn't hear anybody talk about what was planned and plotted was a murder suicide. In other words, one individual plans and plots out the murder of another and then decides to take their own life in the process. So the objects are to kill the victim and then to commit suicide. Now, oftentimes it develops that somebody who plans that feels so much better after killing their tormentor that they decide not to kill themselves. And I didn't hear any expert testimony to rebut what we did hear from the defense, which was fairly weak. I just heard, it's like, do you have any idea what the hell you're doing? Now, Mulroy was supposed to have gotten rid of a lot of Amy Wyrick's appointments who were in there for other reasons than their ability to do the job well. But he didn't hire people that knew what they were doing. He hired politically correct people. And then in the intervening several years, it is obviously apparent if that's who you assigned to this major murder case, that nobody got sent to classes. Nobody got any instruction. The elected DA didn't have anything to teach these people about investigation, one, dealing with the direct examination of a witness by the opposition, cross-examination, jury selection, or final argument. It's all the rules of evidence. It's like, what are you doing there?
Right.
That was, I look, from 1975 up to 2000, I tried a lot of cases, one way or the other, prosecution, defense, or judge. And I've never seen anything that weak.
Wow.
And somebody ought to hold Mulroy very accountable for being responsible for that.
Yeah, wow. And also, like in her, they said there's an interesting take on the judge, because also they said that Daniels was taken into custody and will be sentenced on December 17th. She has no priors, and her attorney said during her 4-year incarceration leading up to trial, she wrote 2 books trying to help others, one for incarcerated mothers, another for children whose mothers are in jail. So, and then she almost killed his wife. My thing is, he wasn't there to defend himself. How you know
wait a minute. Wait.
Yeah.
Testimony on that. I remember his wife escorting me outside of the apartment. And then the next thing I remember, I was standing over their bodies on the kitchen floor.
Okay.
Really? And the prosecution was so inept, they couldn't rip that to shreds.
I mean, it's like, yeah, because it's like they demonizing him, and he's not there to defend himself. And why you trust the word of a person that didn't follow through on killing herself?
Well, but the point
And,
I'm making is, I've done this a lot.
yes, sir. That's what I'm asking
And
you.
I'm looking at the defendant with her own mouth digging her own grave to lay
Yeah.
down in where somebody shovels the dirt of guilt over her. I mean, it's like, how can you get such a beautiful case made for you by a likewise inept defense and you can't do anything with it? It's
Because
like, what's the matter?
they the
And see,
Washington
here's the
General.
other thing. There's sentencing guidelines. She's
Yeah.
apparently a first offender.
Right.
So the sentencing guidelines are going to say, as a range one standard offender, you are liable to only 30% of the sentence if you serve all of what you're going to serve. If you are a mitigated offender, which defense seems to have attempted to set up, then you serve 20%. So that's where you would wind up serving it as the max. Now, the minimum sentence for this is 15 to 60 years. This is not a life in the penitentiary situation. This is 15 to 60 years. So, what is 30% of 15? That's 5. So,
Hmm.
she might walk out the door right after sentencing. Good and honor time, credit. She wrote the books. So 30% of 15's 5 years. That's the minimum if she gets the minimum. And if the judge deviates from the minimum, she has to show cause why on the record. And
Mm.
people don't get what sentencing guidelines are like. Let me ask you a question. What are you going
Hmm.
to pay this year for taxes?
I don't
You
know.
don't know, do you?
I don't know.
Why don't you? You haven't filled out your 1040 form yet. And
Yes.
until you fill out your 1040 form, you don't know what you're going to pay.
Yes, sir.
So it's the same thing with sentencing. Until you go through the sentencing guidelines, you don't know what the person's going to serve.
Yeah, that's a good point. I mean, but I
So
also want.
see,
Go ahead. Yes, sir.
in other words, 15 to 60 years is the range of punishment for a Class A felony.
Okay.
And 30% of the minimum is 5 years.
Mm.
So how long has she been in custody?
4 years, they said.
Well, the offense occurred in 2019.
Hmm. I'm just going back with the media, yeah, what they wrote. I don't know.
Well, I
Know
mean, we
the
can't
actual.
always rely on the media. They don't know
Right, of
shit.
course. That's what I'm saying. That's what I
And
said.
you got amateurs that don't know about the subject. They just get brought in because they know how to put the makeup on.
Right, exactly. Yes, sir.
So um, it's who got anything out of this? This is part of what I look at as being politically correct in prosecution. You're telling the higher ups in the police department, don't touch them. We don't want to deal with people who've only stolen $999.99 shoplifting. Otherwise, let them go.
Mm, yeah.
You've got this food desert where all of these major markets have closed down, Kroger's and stuff like that. I think 11 of them have closed in the Memphis area over the last 10 years. Why? Because they cannot continue to function with the heavy burden put on them by shoplifting that has not resulted in any vigorous prosecution, either by the Warwick administration or by the Mulroy administration.
Hmm.
So what are you saying here? We have our elected officials. This goes back again to theft and death. Not just this case, but it's part and parcel of this thing. Oh my God, criminals are all victims.
Mm,
So let's treat the victims nicely. What about the dead victim? What about the wounded victim? What about the robbed victim, the raped victim, the kidnapped victim, the victim of the burglary, the victim of the whatever you pick to be a criminal act, what about them?
Mm-hmm.
See, but forget that. That's not politically correct. Plus, we have more important things to do. We have to make sure that Cooper Young and Midtown have all of the potholes filled, and we get speed bumps put in, and they are self-contained so they don't come out. And we don't teach the children anything at school because that may cause somebody to be disturbed if some kid gets, embarrassed because there are a disciplinary problem. And by the way, Tennessee is one of those states that still allows corporal punishment of children as long as you don't physically injure them or leave any disfiguring marks.
Mm.
But who am I to say?